Hello, everyone, and welcome to today's event, Preparing for the H-1B Lottery, presented by Envoy. My name is Jamie Gilpin, and I will be your host for today's webinar. Sorry, we're just having some technical difficulties. There we go. Okay, again, presented by Envoy. For those of you who don't know us or aren't familiar, we are the leading immigration services providers. So we combine expert legal representation with technology to provide the only enterprise platform that enables companies to effortlessly hire and manage their workforce across borders. So in detail, that's everything from navigating U.S. immigration to securing global work authorization around the world and business visas to ensuring compliance by tracking and managing all of your international employees. We do this for about 1,000 different companies across various industries and company sizes, and honored to do so and proud of our complete company list. A few housekeeping items before we get started. One, the session is being recorded, so we will provide both the recording and the slides post-webinar in the follow-up email. So you can obviously share with your organization and then hold for your own reference. The presentation will last typically anywhere between 30 and 45 minutes. And so we will have a little bit of time left over for questions. And so if you do have questions, please post those in the right-hand corner of your screen there. Post those and we will be monitoring them and answering them at the end of the presentation. Without further ado, I want to introduce the main presenter and main event of the webinar, Ashley Nolan. So she is an attorney from Global Immigration Associates, which is the law firm associated with Envoy. She's built and submitted hundreds of non-immigrant and immigrant work visa petitions. She has extensive experience handling H-1Bs, of course, which is the main topic today. But she's also had extensive experience preparing Bs and Es and Ls, Os and TN visas as well. Also a native of Canada, so very familiar with the TN side. And as well as employment-based green cards and U.S. citizenship and immigration services requests for evidence, which will also be a topic of today's conversation. So really excited. This is obviously a very busy time for our partners over at GIA, so thank you, Ashley, for joining us and bestowing your knowledge on us of the H-1B lottery process. So without further ado, here's Ashley Nolan.
Great, thank you so much, Jamie. We're very happy to be here with Envoy to discuss the H-1B lottery. Applications to RFEs, it can be a confusing process, so hopefully we'd like to provide some pointers here to get you started and some things to consider in assessing your workforce and deciding whether or not to submit a petition in the H-1B lottery. So just to begin with the lottery in general, Congress does limit the amount of H-1Bs that are available each year. So 85,000 are available. 20,000 of those go to workers that have U.S. master's degrees, so advanced degree holders. The remaining go to the rest of H-1B applicants who must have at least a bachelor's degree. So the way it usually worked before, recently, that these 85,000 are applied for each year, is that the lottery for them opens on April 1st. So we submit our petitions on that date. The lottery remains open for the first 5 business days. If they have received more applications than petitions or H-1Bs that are available, then the lottery will close, and the 85,000 are chosen from those petitions that were submitted. So just looking at these stats here, back in 2011, the cap wasn't reached, so they didn't receive 85,000 petitions for 301 days. Moving down to 2013, it happened in 72 days, and for the past 5 years, they have received more than the 85,000 available in the first 5 days. So that's why the lottery is only open for those first 5 days. So, like I said, once the cap is closed, the first 20,000 will be given to those with a master's degree. The remaining master's degree holders will be submitted into the general pool for the remaining 65,000. The petitions are chosen completely at random. In fact, they are not even opened prior to being numbered and chosen electronically. So unfortunately, there's nothing we can do really to make a petition more likely to be chosen or not. It is a completely random selection. So given this April 1st deadline of when we must submit the petition, how early should you start preparing for the CAP? And, our response is the sooner the better, as early as possible. We do recommend that you audit your workforce and determine, who's eligible for an H-1B, and if there's any other options, if that isn't available, we do suggest that you generally email managers to determine if they have any foreign nationals and if they will need sponsorship in the upcoming lottery. So looking at the H-1B visa in general, just to determine if it is an option for some of your employees. So the first thing you want to do is assess the position for which you're considering sponsorship. So H-1Bs are only available for specialty occupations. A specialty occupation is one that requires the theoretical and practical application of a body of highly specialized knowledge and attainment of a bachelor's or higher degree in a specific specialty as a minimum for entry into the job. So what does that mean essentially? H-1Bs are really only meant for specific positions in which they could not be performed without specific knowledge, essentially. You would want to ask yourself, could this job be performed by someone who doesn't have a particular degree, a degree in X, Y, or Z? If it's possible that that position could be easily performed by a myriad of backgrounds, then it might not qualify as a specialty occupation. So the most common occupational categories that we do see are jobs in computer science, engineering, medicine, law, any type of high-level management, education, math, statistics, accounting, finance. Generally those positions do require a background that you would get in a bachelor's degree in any of those related fields. Some of the categories that we're seeing that are more problematic or more generalized, I should say, for H-1Bs are marketing or social media related positions, communications, general business, or sales. The idea or the issue behind that is that, presumably an engineer could work in a social media related position, but so could someone with a business degree or an arts degree. So these do require specific targeted knowledge in order to perform the role. So we do recommend that, if you've determined that the position does qualify as a specialty occupation, you do then need to assess your employee to determine if they would actually qualify for the visa. The requirement is that if they're going to be performing in a specialty occupation, that they do have a degree that is related to the role that they'll be performing. So we want to look at the job and look at the employee's education. Do they have a degree that is related to the job? For example, if you found a highly talented QA engineer who had been in the industry for several years, but happened to have graduated with a degree in philosophy or sports medicine, then that would potentially be problematic for the H-1B. The employee is required to have that related degree. There are some ways that we could work around an employee's education. There are education evaluations that can be done. We can assess foreign credentials. We can also combine an employee's work history with their education to potentially change the type of degree that they have to accommodate something that would be more related to the role. So once you've determined that you have a role that would be considered a specialty occupation, and the employee that you're considering sponsoring has a related background, related education, and you decide that you want to sponsor them for the H-1B visa. So as we know, the lottery opens April 1st every year. The work authorization that is provided by the H-1B, if approved, doesn't start until October 1st of every year. So there is that time between April 1st and October 1st that, we really need to assess the employee's ability to continue to work for you throughout the summer or even thereafter if they're not chosen in the lottery. A very common scenario is having employees that are, fresh out of university and they're working in their student status, their F1, and they often have OPT or OPT STEM work authorization. So the OPT is a 1 year of work authorization granted right after school, and if the foreign national graduated with a degree in science, technology, engineering, or math, they generally qualify for another 2-year extension. So there is a provision that allows these students that are potentially running out of work authorization after April 1st, but before October 30th, to extend that work authorization while they wait to see about the results of the H-1B lottery. This is known as CAP-GAP. So this is a useful tool, if you do have an employee whose work authorization is expiring over the summer. If they do have work authorization on the 1st of April when we submit the H-1B petition and it expires, say, potentially in June, that can be extended automatically to October 1st if their petition is chosen in the lottery. This, however, does not apply to CPT students, which is another type of work authorization one can have when they're in F1 student status. So that's just something to be mindful of, when you're assessing your employees or potential candidates, are they in OPT work authorization? Do they have the potential to have the extra 2 years of STEM work authorization? And do they expire over the summer? And, would they qualify for this CAP-GAP that would allow you to hire them on and sponsor them in the lottery and hopefully have work authorization throughout the entire summer until it would begin on October 1st. So waiting for the H-1B lottery. Again, once you've assessed eligibility and submitted that petition in April, there are a few mile markers to consider. The first would be whether you want to add premium processing to your H-1B petition. If we file with regular processing, it'll generally take about 2 months to hear if the case was selected in the lottery or not. As I'm sure you can imagine, this can be an anxious time for you and for foreign national employees. So one option is to file with premium processing. What that does is require the USCIS to respond to our petition sooner. It's a 15-day window turnaround. And the way this works for the H-1B lottery is that after we submit the petition in April, they will set a specific date out, say potentially April 25th, where they will say, the premium processing deadline starts today. So we would know 15 days from when that time is set, whether or not the petition was chosen in the lottery and approved. There are a few things that can impact your decision to upgrade to premium processing. We would want to consider any potential expiration dates of the foreign national if they are expiring over the summer, if they don't have the option to extend via CAP-GAP or OPT work authorization, and employees need to travel can also impact the need to know sooner about the petition, and also just family life and deciding if they'll be remaining in the U.S. As I mentioned earlier, the CAP-GAP that serves to automatically extend status can come with some travel restrictions, so that could play a factor as well. And these are all things that you'd want to assess by speaking with your employee, determining all of their expiration dates, and speaking with an attorney to see if there are potential options for keeping them here while they wait for the results of the H-1B lottery. So a very common topic, something that has definitely been more prevalent since the new administration, are requests for evidence. After we submit the H-1B petition, the USCIS does respond either with an approval or a request for evidence. This is essentially saying that they need more information from us or from the foreign national to determine a response to the petition. I just wanted to go through a couple of the very common types of requests for evidence or RFEs that we're seeing from this last year, just to sort of highlight them so potential issues are known and ways to hopefully avoid them. So one of the most common types of specialty of RFEs is a specialty occupation RFE. So as we discussed earlier, the H-1B visa is for the specialty occupation. It is one that requires that specific type of knowledge, that specific degree in order to perform its duties. So this RFE asks for more information about the job and proving that it is a specialty occupation. Generally, we would respond here with, providing extremely detailed job descriptions that explain exactly what the foreign national will do on a daily basis. We also want to include any types of specific technologies, anything technical that the employee would be working with to really highlight the fact that, this job is specialized. It cannot be done unless you have a certain type of educational background. Another very common type of RFE is an in-house employment RFE. This is essentially the government requesting more information about what exactly the foreign national will be doing, how that role fits within your organization, and ensuring that there is enough specialty occupation work available. Here, they would want to see evidence, of ongoing business relationships, clients, contracts, any financial documents or marketing materials that show that, yes, you do have work available for this foreign national, that they will be employed for the entire time that we are requesting. The concern here is that, they don't want the foreign national working on projects that aren't included in the petition, that could potentially include some non-specialty occupation work. The next type of very common request for evidence that we're seeing, which really started, I'd say, about from last year's H-1B lottery, is a level 1 wage RFE. This is essentially the government requesting more information where an employee is paid with a level 1 wage. So in the H-1B petition, we do file what's called a labor condition application. That's essentially a request to the Department of Labor where we indicate what the position is and what the wage will be. There are specific wage levels that must be met for the H-1B program. And so these requests for evidence question where an employee is being paid a level 1 wage, which is the lowest of the 4 possible wages. Essentially, if an employee is making a level 1 wage, that's a certification essentially that the position for which they'll be serving in is a entry-level job. And the issue with that becomes that if it's an entry-level job, well, is it still specialized enough to qualify for an H-1B visa? So that's sort of the first type of level 1 RFE that we can get. There's also essentially where if we're describing the specialty occupation and we're arguing that it's very specialized, that it's complex, it requires a lot of in-depth knowledge, the USCIS could also question why a person is being paid this level 1 wage if the job is so specialized. We really need to highlight the entry-level nature of a job, proving that it's still specialized enough to qualify for the H-1B visa, but just still noting that while it is in and of itself a complex role, it is entry-level with regard to the field in general. The last type of common RFE that we'll see is for off-site employment. So for any organizations that employ foreign nationals at client sites or other offices, the USCIS can request information as to your relationship with the end client. There we would need to prove that the foreign national is still employed by your organization, in that you pay their salary, you are responsible for their performance, for directing their duties, and that you have supervisory rights over the foreign national. So what we do for those is submit statements of work or service agreements, purchase orders, or any other contracts that we can to show your relationship to any end client. And that is really the main topics that I wanted to cover for the applications to RFEs.
Great.
Thank you.
Thank you, Ashley. That was great. There's definitely a lot of nuances, and we do have a couple questions. So just a reminder, if you do have questions, please post them in the question section of the GoToWebinar facility on the right-hand side. And just as more of a PSA, all of this information, of course, without Ashley's great voiceover, but at least the meat of this presentation is in our H-1B Visa Lottery Resource Center. So be sure to check that out, especially if you just want content to reference or you want to do a deeper dive into the H-1B visa lottery and cap survival, what to do, how to do it, and dates to consider. And there you see the envoyglobal.com/H1B, which is all at on our blog or resource center. So a couple questions actually that came up. Some of these will actually be answered in later webinars, but this has to do with alternatives. So if an employee is from India or China, are there other options outside of the H-1B for them to come into the U.S.?
Yeah, so that would really depend on, the status that they're in when they apply for the H-1B. As I discussed a little bit, that it's a very common scenario that people are recent graduates and they're in F1 student status. They have that OPT work authorization. If they're not selected in the lottery, we would want to look at, do they qualify for that 2-year STEM extension? If not, they can always potentially enroll in another degree program. There are some schools that offer programs that do allow for work authorization right upon enrollment. That would be known as the CPT or curricular practical training. Other than that, there are various non-immigrant visa types. They will depend most specifically on the work history of the applicant and on their educational credentials. So, those are mostly case-by-case bases that we need to really do an assessment of those things to say other options.
Great. And there's definitely, there's, the TN for Canada, Mexico, there's the H-1B1 for Singapore, Chile, right? But there doesn't seem to be a direct correlation on the Chinese or Indian options. Mm-hmm. So if we determine, well, this is actually a very similar question. So if it's determined that an employee may not meet the qualifications for H-1B, does Envoy have resources to help the employee find alternatives? Yes, and that is the beauty of working with your attorney at GIA, whether it's Ashley or one of the other folks over there, to determine, just as she was just going over, let's go through the specifics of the work history and figure out what the best next option is.
Yeah, and we do work with some vendors and resources that can help with the things like the education evaluations that I mentioned. They have professional evaluation agencies that look at it for national education from abroad and also from the U.S. to combine them with work experience to determine if we can get them that different degree that they might need. If someone's been working in IT for 15 years, but they have that philosophy degree, we can work to combine those to get them that related degree that would have that H-1B petition approved.
Great. More of a question on filing 2 types of visas at the same time. Can you simultaneously apply for H-1Bs and looks like H-2Bs at the same time?
We don't usually recommend that, but because of the lottery system, you can usually determine what the outcome of the H-1 will be, and the H-2B can be an alternative that's available. It really depends, again, on the situation, the job that's in question, and we'd want to, assess all of that to determine if that is actually a good alternative to the H-1B.
Okay. And similar question, if we have employees that we're applying for the H-1B, should we also start their STEM process in case they're not selected?
Absolutely. If any foreign national in F1 qualifies for any work experience via the STEM extensions, we 100% recommend that they always apply for that, even after an H-1B has been submitted. There could be potential issues. You never know what could happen with the H-1B. So it's always best to have that backup. And of course, if applying is an option before April 1st, we don't know if we're going to be selected. So we want to make sure that they get that extra 2 years, so they get the extra bites in the H-1B lottery. We especially suggested that if someone does have another 2 years of STEM work authorization left, that they still submit an H-1B as early as possible. You don't want to bank on it being selected in the lottery when they're, coming up to their expiration. So the more chances to apply, the better.
Great. And you went over this a little bit, and I think this is definitely more case specific, but it's just a general question on specialty occupation. Any other details or elaboration that you can provide on what that means?
Sorry, Jamie, can you repeat that?
Yeah, so specialty occupation, what does that, at a high level, what does that mean? Is it mainly in the STEM areas? I know you went over marketing isn't typically in that area, and it goes over and beyond. I think it's more of a question of who should we be thinking about for an H-1B?
Yeah, definitely. So again, it's specialty occupations are those really that the job can't be done unless you have an educational background that lends itself to the role. Like I said, you'd want to ask, can this position be performed by someone who doesn't have a specific degree? So generally, like I said, the software engineering roles, anything related to computer science, is just a good example or indicator of what a specialty occupation would be. I think there's very few people that could, just code themselves or develop software without the educational background necessary to do that. Me with my 2 philosophy degrees and my law degree, I, of course, could not code software, so I would not qualify for that. So anything really that the job requires a specific skill set or type of education, and the foreign national has that.
Great. Are there any cases or any situations where an approved H-1B is eligible to work ahead of the October 1st visa issuance?
No. So any petition that is submitted in a lottery that has to go through the CAP, that's not CAP exempt, the work authorization does start on October 1st. Generally, we see where a foreign national is actually abroad and they'll be getting a visa stamp in order to enter the U.S. to start work. Consulates will generally grant them that visa stamp to start September 20th, so they can enter a little bit earlier, but that work authorization doesn't start until October 1st.
Okay. And then due to processing times, and you went over this a little bit in the timeline, is there a deadline for when prevailing wage determination requests need to be submitted?
Yeah, so it's the labor condition application, not the prevailing wage determination. I'm not sure if I accidentally said that, but it is the labor condition application. It takes about 8 to 9 days to be certified by the Department of Labor. So, there are potential issues that can arise when filing the LCA. We do need to categorize the job. We do need to look at the prevailing wages that come along with that category, and those can create some potential issues. So really, like I said, the earlier the better, but the entire preparation of an H-1B along with that labor condition application certification can take about 2.5 to 3 weeks. So, of course, if it's ready to submit, March 1st would be the absolute latest. But again, the earlier the better for any issues that could potentially arise during the preparation.
Okay, great. And there are a few questions that are very specific to a case of an employee. And so Ashley, it would be very hard for her to give, almost impossible for her to give any sort of advice of what an alternative would be for some of these. Like there's a question around transfers that receiving an RFE. So if for very case specific about an employee, because there's so much that goes into the recommendations from the attorneys based on their past work history, make sure you post those. If you are a customer of Envoy, make sure you post those questions into the Communication Center. As all of our customers know, your attorney at GIA is super responsive, and they usually get back within a couple hours, and most of the time within an hour, although CAP season gets a little bit crazier. Mm-hmm. So be sure to post some of these questions there. Are H-1B extensions part of the lottery, or is that a separate?
No, so H-1B extensions would not fall into the lottery. If someone has already been granted H-1B status, they're given 6 years in that status. So the extension wouldn't need to be submitted in the April lottery. One can just extend their H-1B within 6 months of its expiration.
Okay, great. Let's see. There are, again, quite a few very specific questions. So be sure to post those in the communication center or address those to your attorney. How would you know, and this is more just broad, but how would you know or be prepared if evaluations are needed? If the degree is specific to the job, is that exempt? Like, are there best practices there, or is it more of a case by case?
Sure, yeah, I'd say it's a case by case, but generally the USCIS works off information provided by the Department of Labor. So what we really want to do is, look at the position, categorize it in a general type of occupation, and then look that up and, what does the Department of Labor say is a typical degree that a person would have, working in this role. Say we're considering an accountant, obviously a degree in math, finance, economics, accounting would be traditionally one expected of an accountant. Similarly, for a computer science, a software developer, we would typically expect to see, quantitative degrees, math, statistics, computer science, IT, computer engineering, things like that. So, really, I think it would be based on the position in general, the type of degree, and really, your attorney and their experience as to whether the USCIS generally has a problem with the type of degree for the type of role that the person will be in. If it's not related, I wouldn't say that there's no chance for an H-1B. That would be something that we could look into and, make arguments for, and also see if the education evaluation is a good option.
Great. And then, are there any best practices for calculating the dates of intended employment, or is that pretty specific to the role and the company?
Yeah. So for the H-1B lottery, generally the start date would be that October 1st of that same year in which we apply. We can request 3 years of H-1B time on our first application. So generally, it would be, October 1st, say 2018, until sometime in 2021. If you did want your foreign national to start later than that, that's certainly an option, and you could adjust those dates accordingly.
Great. And is there any? So you mentioned getting started as quickly as possible. Are there items or documents that they should start collecting? Is there a good list of those? I know we've got a few lists on the Resource Center, but is there anything just category-wise that they should start looking to collect?
Yeah, from the side of the employee, we're going to need all their biographical documents. We want to make sure that they have their passports available. And that those are still valid and valid into the future. We would need all of their educational credentials, so their diploma, transcripts, things like that could be difficult to get from schools. We want to make sure that we have those on files. Also, anything related to their previous immigration history, so any approval notices that they've had before. If they're students, we would want their I-20s from their school. We would want copies of their employment authorization documents if they're here working in OPT. From the employer side, generally we do require, marketing materials. We can explain, what your company is, what they do, and, why this position is needed, what it will do within the organization, and also speak to that having work available. We generally request financial documents as well. We do have to prove that your organization is operational, and that you do have that work available again.
Great. And speaking of those transcripts you mentioned, if they're in a different language, do they need to be translated?
Yes, we do require for any filing with the USCIS for these April petitions, we would require English translations. We also do have vendors that we work with for those, along with the education evaluations that we would need. Great.
And a little bit on the H-1B alternative side. So if someone's coming up on their 6-year mark, and what are the options after that 6 year? Is it basically green card? I mean, I know there's L's. There's basically other alternatives that they could look at. But is there any any best practice or advice that you would give for anyone that's coming up to their maxed out?
Yeah, I mean, that's a difficult question. There are certain stages in the green card in which, the H-1B can be extended past that 6 years. That would have required sponsorship earlier in the process. Again, I think it's sort of a case-by-case basis. We need to evaluate their work history, their education, to see if there are any options to move them to a different non-immigrant status. There is always the option to depart the U.S. for 1 year and apply again in the lottery, or find an employer that is willing to sponsor you for the green card. Because, as I mentioned, once you get to a certain stage in the green card, you can extend that H-1B past the 6 years.
Great. So I think one of the biggest headlines I saw come from the majority of those questions is, yes, there are alternatives to the H-1B. However, it is absolutely case by case. Lots of, analysis of work history and things like that for each individual. So be sure to post those types of questions into the Communication Center or contact your attorney so that you can go through all of those details and get proper advice. So I think that is it. Appreciate all of the questions that came in. Most importantly, thank you to Ashley, again, knowing how busy all the attorneys are over at GIA. So thank you, both you and GIA, for your time today. And again, thank you to all the attendees for taking time to learn more about the H-1B lottery, employer best practices, and things to look out for. Next webinar that we have will be discussing the riding the wave of immigration policy of 2018. So we'll be discussing policy changes and things on the horizon that could impact employer-based immigration. So look out for that webinar going next. And again, I encourage you to visit our blog where all of these resources are available. Thank you so much and have a great rest of your day.